welcome you to the course on corporate laws and governance. In this video, we are going to learn about the Competition Commission of India. Competition Commission of India was established by the central government on 14th October 2003. Competition Commission of India should have a chairperson. It can have a minimum of 2 members and the maximum number of members that it can have is 6. The members as well as the chairperson is expected to be a person of ability, integrity and standing, and they are expected to have a special knowledge in the field of economics, accounting, finance, business, management, laws including competition law, and they should have a professional experience which should not which for a minimum of 15 years in the chosen field. And all these members are the whole time members of the Competition Commission of India. If we see the composition of Competition Commission of India, as on February 2024, Mrs. Ravneet Kaur is the chairperson and she is a member of IAS. She has profound experience in the field of finance, accounting and budget matters. She had served in different government departments of financial services, disinvestment and economic affairs. One of the members of the Competition Commission of India right now is Shri Anil Agarwal. He is the 1988 batch of IPS. He had been a part of the several government initiatives like Make in India, Investment Promotion, Startup India, E-commerce, International Trade, Technical Regulation, etc. One more member that we have right now in the Competition Commission of India is Ms. Shweta Kakkad. She is a lawyer by profession. She had been handling different disputes which varies from civil to corporate litigation, and she had been handling both the national and the international clients. The third member that we have right now in the Competition Commission of India is Shri Deepak Anurag. He is the 1988 batch of Indian Audit and Account Services. And if we look at the experience that he has, is he is having experience in the field of public auditing, finance and accounts. Now let us see how this Competition Commission of India members are selected. We have a selection committee, and if we look at the selection committee, we have the Chief Justice of India or his nominee who would be selecting the chairperson. The other members in the Competition Commission of India would be selected by the Secretary in the Ministry of Corporate Affairs, the Secretary in the Ministry of Law and Justice, as well as 2 experts of repute who have special knowledge in the field of economics, management, business, finance, accounts, law, technology, etc. would also be selecting a member. If we look at the period of office for this for these members as well as the chairperson, they can hold the office for a period of 5 years, and they can be reappointed for the post provided they haven't attained the age of 65 years. In case there is going to be a vacancy for the position, either for the chairperson or for the members due to their resignation or due to their removal from the post, then fresh appointments would be made, and the government would be following the rules and the provisions that have been mentioned in Section 9 of the Competition Act. In case the chairperson's position is vacant until the appointment happens for the vacant post, the senior most member in the Competition Commission of India would be taking care of the activities of the Competition Commission. Yes, even when not only due to the vacancy, in case the chairperson is going to be absent due to illness or due to any other reason, then the senior most member would be in charge of running the Competition Commission of India. If we look at the meeting of the commission, the members as well as the chairperson would be meeting on the prescribed dates and the prescribed time and as per the regulations of the Competition Act. If we see, like, decisions are made in the meeting, and the decisions would be made based on the majority vote. In case there is going to be a tie in the voting for taking a particular decision, then a second vote would be given to the chairperson in order to break the tie, but on the condition that the quorum for the meeting is at least 3. That is important. In case the chairperson is not there and the meeting had been convened by the senior most person of the Competition Commission of India, then the senior most member would be given the second vote in order to break the tie. Now let us look at the duties of the Competition Commission of India. We all know that the 3 important activities of the Competition Commission of India is, one is to do with the prohibition of the anti-competitive agreement, another is to do with the prohibition of the abuse of dominant position, and the third one is to do with the regulation of combination. Section 3 subsection 1 deals with the prohibition of anti-competitive agreement, and section 4 subsection 1 deals with the prohibition of abuse of dominant position by any enterprise, and section 5 and 6 deals with the regulation of combination. So here when we look at the duties, first let's go with one by one. First we will look at what are all the duties that the members as well as the chairperson has with respect to the prohibition of the anti-competitive agreements. Normally they will look into the agreements which seem to be anti-competitive in nature, either by getting information from the consumer or from the producer, trade association or the consumer association, based on the information which had been given by any of these stakeholders by following the prescribed rules and by paying the prescribed fee. They will start the investigation. Sometimes the investigation would also be taken up on the reference by the central government, state government or by the statutory authorities. So whatever be the means of investigation, one of the duties of the Competition Commission of India is to ensure that they look into different factors while determining whether a particular agreement is anti-competitive in nature, in the sense whether it creates an appreciable adverse effect on competition. With respect to the anti-competitive agreement, what the factors that the Competition Commission of India is expected to look into are, like, they need to look at whether such an agreement results in any kind of prevention of entry of new firms, or whether there is a kind of agreement among the existing players, could be the producer or for that matter the supplier or the distributor, with respect to price fixation in the particular geographical area or with respect to a particular product market, or whether these stakeholders are involved in any kind of collusive bidding. Yes, and if these stakeholders are involved in any kind of prevention of the existing firm in terms of development, technological development, scientific development, or in the coming out with some kind of innovation, if there is going to be any such activities, then they have to verify all these things before declaring a particular agreement as anti-competitive in nature. So that is one thing which the Competition Commission of India is expected to look into while investigating the anti-competitive agreements. Whenever they are going to assess whether there is a prohibition of whether there is any abuse of dominant position by any of the players, whether by the distributor or by the producer or the supplier for that matter, they will have to look at different factors. It is a duty to look into different factors to assess whether there is a dominant position. It is not only the market share. Market share is one of the factors which the Competition Commission of India would be looking into to assess the dominant position of a particular company in the industry, but they should also look at other factors like the extent to which the consumers are dependent on the firm for the goods and services. They will have to see the market structure as well as the share of the different enterprises in the particular market. They have to look into how strong the vertical integration is there for the enterprises in the market. They need to assess whether a particular company enjoys dominance because of statute power, in the sense being a because of being a government company or because of being a public sector undertaking, a company might be enjoying a dominant position. They should also see whether the particular enterprise enjoys the dominant position because of the relative advantage that it has, and they could contribute to the economic development. They should look into factors like the social cost, social obligations. So there are so many factors which the Competition Commission of India should look into in order to assess whether a particular enterprise enjoys a dominant position in the industry. So it is their duty to look into these different factors, and whichever factors which they feel that is relevant to assess the dominant position. Then with respect to defining the relevant market, because defining the relevant market comes into the picture whenever investigation happens for either for assessing the dominant position of the company or for assessing the anti-competitiveness of the agreement. So whenever we talk about the relevant market, we talk about the relevant product market as well as the relevant geographical market. So when we look at this relevant product market, it is the duty of the Competition Commission of India is to look into a list of factors like the consumer preferences, the characteristics of the product, the price of the product, the existence of specialized product, the exclusion of in-house production, industrial classification. So these are all the factors which the Competition Commission of India is expected to look into while defining the relevant product market. When they want to define the relevant geographical market, it is the duty of the Competition Commission of India to look into the factors like any kind of local regulatory barriers that exist, the kind of distribution facilities that are available, the specific requirement of the local needs, consumer preferences, transportation cost, the extent to which the people in the particular region require the speedy supply or they require the speedy access to the after-sales service. So all these factors or any other relevant factors which the Competition Commission of India thinks that is important should be looked into while defining the relevant geographical market. Now, next let's look at the combinations. So what are the duties the Competition Commission of India has while assessing the combination deals? Normally, if we look at it, Section 5 and Section 6 of the Competition Act deals with the combination, the regulation of the combination. Normally, this assessment of combination would happen by the Competition Commission of India either on their own knowledge or by getting the notice from the companies. Whenever the companies goes for consolidation or the combination like the mergers, acquisition or amalgamation, if the turnover or the asset are going to exceed the threshold that's been fixed by the Competition Commission of India. So it is the duty of the Competition Commission of India to assess it. And as per if we look at it, the period within which the assessment has to be done was 1 to 10 days, which has been reduced to 150 days as per the Competition Amendment Act 2023. And so while doing this combination, assessing the combination, there are some factors which the Competition Commission of India is expected to look into while assessing whether a particular combination results in the appreciable adverse effect on competition. They have to check what is the actual competition that the particular industry faces from import, and what are all the potential competition which the industry would face through imports. They will have to check that, and they will also have to check, like, because of the combination, what happens to the prices of the product. Does the price of the product increase due to the combination? Do consumers get exploited where they are prohibited of having more variety, or where they are expected to pay a higher price because of the combination? Does the combination affect the competition intensity that exists in the particular industry? Does the combination bring in innovation? Does the combination enjoy any kind of relative advantage which contribute to the economic development? So all these factors have to be looked into by the Competition Commission of India while assessing while investigating the combination, and while assessing whether the combination results in appreciable adverse effect on competition. In case a combination has happened and a period of 1 year has gotten over for that particular combination. When I say combination, we talk about either the merger, acquisition, or for that matter amalgamation. So when all these things get over and where it has gotten over for a period of 1 year, beyond that period the Competition Commission of India cannot start the investigation to check whether the particular combination results in appreciable adverse impact on the competition. They cannot do that. These are all the duties of the Competition Commission of India. Now let us look at the powers that the Competition Commission of India enjoys. Section 27 of the Competition Act 2002 deals with the powers that the Competition Commission of India enjoys. The first power that the Competition Commission of India has is that they have the power to tell the companies that are involved in any kind of anti-competitive agreement to discontinue that anti-competitive agreement, and they should not re-enter such kind of agreement in future. So the Competition Commission of India has the power to do that. The next power what it has is that it has the power to tell the companies who are enjoying or who have the dominant position and who have abused their dominant position to discontinue such kind of abuse of dominant position. The next power that the Competition Commission of India has is to do with the penalty that it can levy on the cartels. When there is going to be a cartel arrangement, either among the producer or among the supplier or among the distributor, then the Competition Commission of India has the power to levy the penalty of up to 3 times of the profit for each year of continuance of such agreement by the group of producers or the group of suppliers or by the group of the distributors, or either they can go for 3 times of the profit for each year, or what they can do is they can go for a penalty which would amount to 10% of its turnover for every year of the continuance of such kind of agreement, cartel agreement, and they will choose the one that is higher. If the penalty that comes out of profit is going to be higher than the penalty that's been charged out of the turnover, then they will go for the penalty that is calculated on the profit. and it is other way around. If the turnover, if the penalty that's been charged from the turnover is going to be higher than the penalty that's been calculated from the profit, then they will go for the penalty that's been calculated on the turnover. The next power what the Competition Commission of India has is that it can impose any penalty which it feels that fits to the kind of anti-competitive agreement or the abuse of dominant position, and they have every power to direct that the agreement shall stand modified. They can give direction to the companies to change or modify their agreement which are anti-competitive in nature. They also have the power to direct the enterprises concerned to abide by such other orders or pass such other orders or issue such directions which it deems fit for the occasion. So, these are all the powers that the Competition Commission of India enjoys. Next, let us look at the functions of the Competition Commission of India. The first function of the Competition Commission of India is to ensure that the interest of the consumers are protected. When if a particular trade is going to be unregulated in nature, it results in the exploitation of the consumers. So, the very purpose of having the Competition Commission of India is to ensure that the welfare of the consumers are protected and they are not exploited at any stage. So, the Competition Commission of India actually advocates for free trade, but they are not for unregulated trade which may result in the exploitation of the consumers. The next function of the Competition Commission of India is to ensure that there is proper utilization of the national resources when there is going to be exploitation and when there is going to be an anti-competitive agreements among the different players in the market. What happens? This results in the inefficient usage of the resources. For instance, the companies may limit or restrict the supply of the material so that they can charge a higher price. They may create an artificial scarcity in the market with the intention of charging a higher price. When we look at it here, there is actually underutilization of the resources. There is no efficient utilization of the resources. So, what Competition Commission of India does is it ensures that the resources are utilized to the maximum possible extent in the most efficient way by the enterprises. The next function of the Competition Commission of India is the competition advocacy. Whenever a central government or the state government comes with various policies, they would be requiring advice from the Competition Commission of India. So, it is mandatory for the Competition Commission of India to give their opinion on the different policies which the government is planning to come out with. So, whenever the government approaches them for their opinion and advice, so the Competition Commission of India should extend their opinions, and it is not a compulsion on the part of the central government to follow whatever that's been recommended or suggested by the Competition Commission of India. But as and when the government requires any kind of support or help with respect to the policy formulation, it is the duty of the Competition Commission of India is to extend that help, which is one of their functions. The next function is to create awareness among the different stakeholders of the business, like the consumers, producers, distributors and the suppliers, to know about the various provisions that are there in the Competition Act, so that they can approach the Competition Commission for any of their problems. The next function of the Competition Commission of India is the antitrust ombudsman. Here, if we look at it, the Competition Commission of India actually protects the small and the medium scale enterprises from getting exploited from big enterprises, the multinational corporations and the conglomerates. So basically they act as the antitrust ombudsman for the small and medium enterprises, and they ensure that these small and medium enterprises coexist and there is an inclusive growth in the industry. So this is what the Competition Commission of India ensures, that these small and medium scale enterprises are protected from the big enterprises. And the next function of the Competition Commission of India is to ensure that the competition laws are in tandem with the other regulatory laws. Well, for instance, we talk about the laws of Securities and Exchange Board of India. We have the rules and regulations for by the Reserve Bank of India. Almost every sector has a regulatory body, like we have for telecommunication, we have TROI, and for insurance, we talk about IRDAI. Like whatever laws that the Competition Commission of India comes out with, it should be in tandem with the laws of these regulatory bodies like SEBI, RBI, IRDAI, TROI, etc. They ensure that it is in tandem, right? And another function of the Competition Commission of India is to ensure that the foreign companies abide by the competition law that exists in India whenever they operate within the boundaries of India. Next, let us look at the penalties that are there under the Competition Act 2002. If we look at it, like in case the companies fail to comply with the directions that are given by the Competition Commission, or if they fail to comply with the directions that are given by the Director General, then the companies would be penalized. They would be penalized for each day of non-compliance, and it would, for each, if they are going to be non-compliant on a day, then they would be fined to the tune of ₹1 lakh. So this will keep on increasing, in the sense every day they would be penalized to the extent of ₹1 lakh. And until they comply with the directions of the Commission and the directions of the Director General. But this penalty can reach only up to 1 crore rupees. It cannot go beyond that. So when we see this compliance with the directions, after the investigation, the Competition Commission of India and the Director General would be giving directions like modifying the agreement or to do away with the agreement. So these are all some of the directions that would be given by the competition, either by the Competition Commission or by the Director General, and it is the duty of the companies to comply with all these directions. In case they fail to comply with all these directions, then every day they would be penalized the amount of ₹1 lakh, and this would keep on going until they comply with it, but the penalty cannot go beyond 1 crore rupee. In case the companies are not going to furnish the information to the Competition Commission of India when they file the notice to the Competition Commission of India for their approval. So when they are expected to give all the relevant information about the amalgamation, merger, acquisition at the time of filing the notice to the Competition Commission of India for their approval. In case they fail to give some of the informations which are pretty relevant for these combinations, then they would be, these companies who have failed to give that information would be penalized, and the penalty would be either 1% of the turnover, or it would be 1% of the assets, whichever is higher, that would be taken as the penalty. The next penalty that we have is when the companies are going to give false information, or when they omit, or when they omit furnishing certain information to the Competition Commission of India when the investigation is going to be in progress, then they would be penalized, and the penalty would be a minimum of ₹50 lakhs, and it can go up to 1 crore rupees. Next, let us make a comparison between the Monopolies Restrictive Trade Practice Commission with the Competition Commission of India. So, we all know we had, before the Competition Commission of India, we had the Monopolies and Restrictive Trade Practices Act, wherein we had the Monopolies Restrictive Trade Practice Commission to carry out the investigations. First, let us look at the scope. If we look at the Monopolies and Restrictive Trade Practices Commission, the major function of the Monopolies Restrictive Trade Practice Commission is to ensure that there is no monopoly, restrictive trade practices or unfair trade practices. So, there were only three objectives, like to ensure that there is absence of monopoly and there is prohibition of restrictive trade practices as well as unfair trade practices. But when we look at the scope of Competition Commission of India, here Competition Commission of India does not say like being a monopoly is bad. In the case of MRTP, a company cannot be a monopoly. That itself, being a monopoly itself is considered to be bad. But in the case of Competition Commission of India, a company can be a monopoly, only thing they should not misuse it. Yes. So, if you look at the Competition Commission of India, the scope of Competition Commission of India is into three aspects. One is to do with the prohibition of the anti-competitive agreement, another is to do with the prohibition of the abuse of dominant position, and the third one is to regulate the combination. So, with respect to the Competition Commission of India, being dominant is definitely not bad, and only when there is going to be misuse of the position, then it is considered to be bad, in the sense they will carry out the investigation, and once they prove it, a penalty would be imposed. So, when we look at the factors that are looked into while determining the monopoly, MRTPC was actually determining the monopoly only through one factor, that was the market share. But if we look at the Competition Commission of India, it does not deal only with the market share to determine the monopoly position of the company. It deals with varied factors which I have already mentioned, like the structure of the market, the social obligation and the social cost, the extent to which the consumers are dependent on the enterprises, the extent of countervailing buying power in the particular industry, whether a particular industry enjoys dominance because of statute power. So, there are umpteen factors which the Competition Commission of India looks into while determining the monopoly power of a company, and it is not only the market share. So, that way Competition Commission of India is pretty broader. And if we look at the Monopolies and Restrictive Trade Practices Commission, they normally go only with one order called cease and desist orders. They will say if they find that a particular enterprise is into unfair trade practices or any kind of restrictive trade practices, and if they find out that a particular company enjoys monopoly in a particular industry, so the only way is that they stop them from doing it. But in the case of Competition Commission of India, if we look at it, they actually stop the companies from doing it by levying penalty. So, actually when the penalties are levied, it automatically discourages the companies to get involved in similar activity in future. So, that is another difference that we have between the MRTPC and the Competition Commission of India. And the next one what we have is to do with the cartel. Whenever there is going to be a cartel arrangement, what Monopolies and Restrictive Trade Practices Commission does is actually it monitors the price movement. Actually monitoring the price movement and proving that there was a cartel arrangement among the companies becomes very, very tough. But Competition Commission of India has this leniency provision, in the sense if the people who are involved in the cartel arrangement, if the members are ready to give the information about the cartel arrangement, then the Competition Commission of India would be actually reducing the penalty which they will have to pay for such an anti-competitive agreement. So these kinds of leniency helps the Competition Commission of India in cracking the different cases relatively easier. Next, what we have is to do with the registration of agreements as per the MRTPC. All the agreements that the enterprise enter into should be registered with the MRTPC, in the sense with the Monopolies and Restrictive Trade Practice Commission. Whether it is anti-competitive or not, any agreement that the company enters into should be filed with MRTPC. This actually makes the work pretty difficult for the companies. But when we look at this Competition Commission of India, here they do not compel, or they haven't made it mandatory that any agreement should be registered with the Competition Commission of India. Whenever the Competition Commission of India on their own feel that there are some agreements which are anti-competitive in nature, they pursue the investigation, or whenever they get any information from the producers or the distributors or the consumer association or the trade association with respect to the suspicion of any kind of anti-competitive agreement, then again they carry out the investigation. So if we look at the difference, we can understand that the Competition Commission of India is towards a free trade, and they want to have a very healthy competitive environment in the country for its economic development. Finally, let's look at some of the challenges that the Competition Commission of India has. The first challenge what they have is to do with the awareness level. Because we know that one of the functions of the Competition Commission of India is the competition advocacy. It is their duty to bring awareness among the stakeholders about the various provisions that are there in the Competition Act. Only when people are aware, only when the consumers, producers, suppliers and the distributors know that there are provisions in the Competition Act which help them to resolve the problems that they face at their level, then only they will be approaching the Competition Commission of India and they will be asking for investigation. So creating awareness is one of the biggest challenge that the Competition Commission of India, of course they do it by conducting the workshops, they coming out with circulars for the companies, by doing seminars. So they do it. Despite that, this awareness to be increased among the different stakeholders in the industry to ensure that people utilize the services of the Competition Commission of India, and ultimately it results in creating a very healthy competitive environment. The next challenge what the Competition Commission of India has is to do with proving that there is an anti-competitive behavior by the enterprise. So proving it is going to be tough, in the sense they need the cooperation from the different players in the market, the consumers, trade association, consumer association, or different people who are involved in the particular case should be willing to give information. So gathering information and proving that there was an anti-competitive behavior in the market is definitely challenging to the Competition Commission of India. So normally if we look at it, the cases, it takes years to complete, for the reason that the investigation requires more information, for which they require the cooperation of the different stakeholders. So basically if you look at it, the legal proceedings are very lengthy. So this is one of the challenge what they have. The next challenge is to do with the resource constraints. We did see, like the Competition Commission of India has a chairperson, and they can go for the maximum of 6 members. So sometimes when they are going to have less numbers than what they are required to, in the sense than what is the maximum. So this is also one of the resource constraints in order to take up the different issues that happens in the competitive environment. So having the resources in terms of manpower itself is one of the constraints which the Competition Commission of India faces. The next is to do with digitalization. Nowadays, almost all the enterprises have gone for digitalization. All the companies in across the industries have digital presence. So somewhere down the line, the Competition Commission of India has to prove the digital dominance of these companies, and they'll have to look into different laws like the privacy law, the security law. All these have to be looked into, and this is definitely a challenging one, because this particular field itself is pretty dynamic, and the digital dominance is very much prevalent now due to the digitalization of the companies across industries. So this itself is a challenge to the Competition Commission of India. Then the next what they have is to do with the penalties. We did see like the penalty actually acts as a deterrent in stopping the companies in involving themselves in any kind of anti-competitive behavior. But is this penalty good enough to discourage them to get involved in any anti-competitive behavior is a question mark, right? So the penalty, so that is one of the challenge that the Competition Commission of India faces. Another is like the Competition Commission of India, through the investigation by the Director General, they would be coming with a verdict, and that itself is a lengthy procedure. It takes years for them to prove that there was an anti-competitive behavior, and once they prove it, what happens? It doesn't end there. There is always a provision for the person who's affected. The enterprises will go to the next level. They will go to the either to the appellate tribunals, because we do have competition appellate tribunal. When they are not satisfied with the verdict of the Competition Commission of India, these companies who are affected, they will take the matter to the next level, namely the Competition Appellate Tribunal. If they are not going to happy with the Competition Appellate Tribunals, they can still go to the Supreme Court. So there are judicial intervention. So enforcement of law is going to take time. Just because the Competition Commission of India comes with a verdict, it doesn't end there, because people take it to the next level. So again, it is going to take time. So these are all some of the challenges which the Competition Commission of India faces. Thanks for listening.